Good evening, everyone, and welcome to our live stream. This is today's Tax Talk. It is Thursday, May 18th, the year of our Lord 2023. I'm your host. I'm attorney Stephen Leahy. And today we're going to talk about the U.S. Supreme Court. They released a much anticipated decision in the case titled Polselli versus the IRS. Right up my alley. You won't want to miss it. Won't you join us? Okay, so the court came out with this decision. I've covered it on this show before in anticipation. I should have known better, and I pretty know. But I'm always hopeful that some of these cases will limit the power of the IRS. But this case didn't do it. I had talked about this case in the Fourth Amendment constitutional law that it's a violation of privacy. The court never even got there. Never talked about that. So the United States Supreme Court ruled in this case that the IRS does not need to get to notify third parties when requesting a summons for banking records for tax collection purposes. So I help people in tax collection. I work with the collectors, IRS collection department all the time. And, they do issue summons and they go after your bank records and things. And in this case, what happened was that it involved Remo Polselli, who had an outstanding balance of more than $2 million in federal taxes. I have cases. I have a lot of cases like this. So the IRS issued a summons to the banks where Polselli's wife and his lawyers had accounts, and they didn't notify either one of them. And so they brought this case. The lawyers and the wife brought a case saying, "Hey, you should have given us notice." And so we couldn't go to court and object. And they brought it to court, and the lower court threw it out, said we don't have jurisdiction because there's an exception to the notice, and it falls within the exception. And so they just dismissed the case. And they went to the Sixth Circuit, and the Sixth Circuit said, nope, the district court's right. Now, there had been some conflict in decisions in the Seventh Circuit, I believe it was the Seventh Circuit, the Ninth Circuit, and the Sixth Circuit. So the Supreme Court took it up, and again, there was a lot of anticipation, hoping that that the court would say, hey, the IRS overstepped their bounds. They have to send notice. These third parties really didn't have anything to do with it. And so you shouldn't be able to go into their records to find out about his tax debt without notice. And the court supported the IRS interpretation of the section of the tax code, which exempted the IRS from giving notice to the summons if the summons is issued. And here's the key phrase: in the issued to aid tax collection. So that's the exception. So if they were trying to aid tax collection, if getting these records would aid tax collection, then there is an exception. They don't have to send a notice. And they're saying, well, to aid tax collection for who, right? And that's really what the plaintiff was saying. The attorneys and Polselli's wife, what they were saying. So the court stated that the statute does not require a taxpayer to have a legal interest in the records that the IRS had summoned. So that was the argument, right? Hey, court, they don't have a legal interest. They shouldn't be able to do that. Mr. Polselli didn't have an interest in my records, and so you shouldn't be able to go after my records for Mr. Polselli, to collect on Mr. Polselli. But again, the court said no, that there was an exception. And the IRS argued that notifying the taxpayer could result in them moving the assets before the court can act. And that makes sense in the sense that, if you alert everybody that they're saying, and one of the things here is there was a office building, I believe, that Polselli had made, or a hotel, I believe it was, and Polselli had made payments to the IRS through an account of this hotel previously. So the court is saying, well, he didn't have does he have a legal interest in a hotel? They didn't know, but they knew that he could write a check from there. So they started investigating there. Same thing with his wife. Could he had hidden assets there? And he could have had some hidden assets there. And so that this was the aid that they were looking for, right? The aid to collection. And the court said that that was enough. So while the court upheld the IRS's position, in this instance, it did not define the full extent of the IRS's authority to issue the summons, implying that there could be future clarification on this matter. And so you got to look for exactly the right case. Again, I'm always hopeful that the court is going to make some broad decision, but we generally know the court is always looking for some narrow way to come up with these decisions, to make it very narrow. Now, one thing I was very surprised of, fairly surprised, I should say, not very. But the new Justice Jackson, she wrote a concurring opinion of which Gorsuch joined. And what she said was, yes, they had enough power because this was a unanimous decision. I don't think I mentioned that, but right, this was a unanimous decision. So all the whole court agreed with this. But Jackson and Gorsuch wrote joined in a separate opinion, and they're saying, hey, just because we find this now doesn't mean the IRS has unlimited subpoena power or summons power when it comes to collections, that there is a limit. What that limit is, we're not sure of, but there is a limit. And so they can't just use this exception to always do whatever they want to do. I would like to see more boundaries put in, but they say this wasn't the case for the boundaries, and that's what the Chief Justice Roberts wrote the majority opinion, and actually it was unanimous opinion, and he wrote that, and he said the same thing. This is not the case that we're going to find the boundaries of the IRS's authority, because this isn't the case. That wasn't brought up in the case, and the question presented to the court wasn't about the Constitution. It was about statutory interpretation. And so that's what they did, statutory interpretation. And actually, I think, sometimes as an attorney, you have an opinion of the way things are. And if you write a brief, you get very certain of what the outcome should be until you read your opponent's brief, and then you say, oh, that makes a lot of sense too. And sometimes it brings it to your attention, and that's kind of what this opinion did. I think it was a very good. Now, I always recommend people go to the Supreme Court's website, read this case, just a summary of this case. I should put out I'll try to come up with a link, because now my son Jake, he has a podcast where he reads the summary of all the Supreme Court cases now. So if you're not going to read it, then listen to it. It's there. So I'll have to make that available for people. He just got involved in this, and again, I'll have to make that. Maybe I could put that on here too if I could find it. So, but again, if you can't listen to it, then read it. All of us should understand kind of the limits and what the court is saying in these cases. Again, I would have preferred that they limited the IRS's authority, but I kind of understand why they went the way they went, given the facts of the case and the question presented. So anyway, that's what I think. What do you think? Put it in the comments. Love to hear your opinion about this. It's a great case. Again, whenever you're in a certain area of the law, like I am, in collections in the IRS, and a Supreme Court case comes out, it's pretty important, right? I do some bankruptcy law too, and occasionally the court will come out with a bankruptcy case, and it's like, whoa, you take a special interest in it, because it doesn't happen very often. And so I took a special interest in this case. I've talked about it several times. I talk about it again today. So thanks so much for joining us. I appreciate you taking the time, and we will see you on another time. In the meantime, we are now out.